OK, to the Court of Appeal now, and a judge is deciding whether the sentences of 3 teenage boys who were convicted of multiple rape and sexual offences against 2 girls in 2024 were unduly lenient. Now, the boys, who were aged 13 and 14 years old at the time, were given non-custodial sentences, with the judge saying he wished to avoid criminalising them unnecessarily. Our correspondent Sadia Chowdhury is at court. She sent this update.
Well, you may remember this case. There was a huge public outcry following sentencing in May when the judge had opted to give these boys non-custodial sentences. Many people had criticised that decision, saying that actually a prison term, detention, would have been more appropriate. The Prime Minister himself weighed in, saying that it was right that this case be reviewed. The Attorney General, whose job it is to look at these cases, he agreed. He said he had no doubt when he looked at the evidence that this was a decision that needed to be looked into, and that is why we're here at the Court of Appeal, where a panel of 3 appeal judges have been looking into that decision, the sentencing decision, and to see if it needs to be changed, essentially. And what they've heard over this 2-day hearing is arguments from the Attorney General's side about this being an unduly lenient sentence. Perhaps detention would be more appropriate, but they also heard from the boys' lawyers, who talked about youth rehabilitation orders being appropriate because children under the age of 14, for them, custody should be a last resort, they said. And they pointed to reoffending among children who are sent into custody, those rates being particularly high. They argue that the youth rehabilitation orders are the appropriate one. But this had caused a massive outrage throughout the country when it first happened. There were lots of arguments all over the internet. You might remember of people criticising the judge, a lot of sort of heat on the judge, a lot of political energy around that. There's even a petition still online calling for him to be removed. So a lot of people will be very carefully watching today's decision. And yesterday in court, one of the things I should mention is that the judges talked about a CPS, a Crown Prosecution press release that had been issued just after sentencing, which had some wrong facts in it. They had wrongly said, and remember the CPS are the guys who decide which criminal cases end up in court, they had wrongly said that one of the girls was raped at knife point and that she had essentially been kidnapped because she'd been forced to leave her devices behind so that she couldn't be traced. In fact, not only was that not true, the judge had categorically ruled that out, saying that there was no knife involved and that she had left those devices behind by her own choice. So a really controversial sentence it ended up being.
We do have an update on the case because 2 15-year-old boys who were spared custody, as Sadia is saying, for the rape of 2 girls in Fordingbridge in Hampshire, they have been sentenced to 4 years detention. This is after a Court of Appeal ruled their original sentences were unduly lenient. Let's just remind you of the case here and what we're talking about, because 2 girls, they were aged 14 and 15 at the time. They were attacked separately in Hampshire. This was in November 2024, and it was in an underpass in near the River Avon. This was after meeting the boys in a park, and the 2 boys who were involved in the attacks, the youngest being 13, they encouraged to film the attack on the girls, one at knife point, 2, and now they were given a Court of Appeal ruling this afternoon, and they were being looked into whether this was non-custodial sentence of the teenage boys. Well, it's now been ruled that they, who were originally spared justice, they've now been given 4 years detention. Let's go live now to the court and hear a little bit from the judge in this case.
Written judgment with a written press summary, which is available to everybody. The neutral case citation number is 2026 EWCA Crim 845. The judgment will be put on the National Archives in the normal way. We propose to give a short oral summary of that judgment now. We remind everybody of the reporting restrictions which are in place. This was a difficult sentencing exercise. given the number and seriousness of the offences, but also the ages and vulnerabilities of very young children. The judge carried out a careful sentencing exercise in accordance with the statutory principles and the sentencing guidelines that he was required to follow. However, we decided that the non-custodial sentences which were imposed by the judge on X and Y were unduly lenient. X was convicted of an offence of rape committed against C1 in a first incident, and a further offence of rape against C2 in a second incident. Y was convicted of 3 offences of rape against each complainant in each incident, 6 rapes in all. Both X and Y were also to be sentenced for their part in filming these offences. Each incident involving rape by more than one offender was extremely serious, but the fact that they repeated their behaviour after the first incident and did it again to a different person in the second incident is the crucial feature of these cases. It rendered a significant sentence of detention for X and Y unavoidable. Z, on the other hand, was involved only in the second incident and was convicted of 1 offence of rape by encouraging Y to commit the offence against C2. He is younger than X and Y, and in his case, the judge's sentence was not unduly lenient, and the Attorney General's application in his case has been dismissed. We're going to give a quick summary of the facts and the reasons. Following a 29-day trial in the Crown Court at Southampton, the 3 offenders, X, Y and Z, were convicted of rape and other sexual offending that had taken place in Fordingbridge, Hampshire, against 2 separate complainants, C1 and C2, on 2 separate occasions. The first incident occurred on the 26th of November 2024 and involved X and Y only. The second incident occurred on the 17th of January 2025 and involved all 3 offenders. Each offender had pleaded guilty shortly before trial to offences of taking indecent photographs of a child. X and Y were both aged 14 at the date of the first and second incidents, and 15 at the date of conviction and sentence. Z was 13 at the date of the second incident and 14 at the date of conviction and sentence. The complainants were also young. C1, the complainant in the first incident, was 15 years old at the relevant time. C2, the complainant in the second incident, was 14 years old. We have set out the circumstances in which the offending took place and the details of the individual offences in paragraphs 20 to 41 of our written judgment, and reference should be made to those paragraphs. We also set out specific findings made by the judge at paragraphs 75 and 76 of our written judgment. The offenders were sentenced on the 21st of May 2026 by the trial judge. In respect of X and Y, he passed a youth rehabilitation order with intensive supervision and surveillance programme for a period of 3 years. In respect of Z, he made a youth rehabilitation order for 18 months. The requirements attached to each included supervision, a curfew, and compliance with specialist harmful sexual behaviour intervention. The Attorney General sought, and we granted him leave, to refer the sentences to the Court of Appeal Criminal Division under Section 36 of the Criminal Justice Act 1988 on the ground that the sentences were unduly lenient, increased. It was argued that the extent and nature of the offending was so serious that non-custodial sentences could not be justified, and that sentences of detention should have been imposed on the child. In particular, it was argued that the judge had wrongly assessed the level of harm caused to the 2 complainants, and, in respect of X and Y, had had insufficient regard to the number of offences and the fact that they had repeated their offending behaviour. In response, it was argued on behalf of each child that the judge who had heard the facts at trial was best placed to make decisions about the level of harm caused and the seriousness of the offences. Reliance was placed on the very young ages of each of the offenders, their own vulnerabilities, and their prospect for rehabilitation. The court was reminded that custody for a child is a sentence of last resort, and that the court is required to take an individualistic and child-centred approach in order to fulfil the statutory requirements, to have regard to the principal aim of the youth justice system, which is to prevent offending or reoffending by a child, and to have regard to the welfare of the child. Any judge passing sentence, and this court on appeal, must apply the statutory framework enacted by Parliament as contained in the Sentencing Act 2020. Section 230 of the Act states that a court must not pass a custodial sentence unless the offence is so serious that no other sentence can be justified. In forming that opinion, the court must take into account all the information that is available to it about the circumstances of the offences and any aggravating or mitigating factors. Section 63 of the Act sets out that the assessment of seriousness is to be made by considering the offender's culpability in committing the offence and any harm which the offence caused, was intended to cause, or might foreseeably have caused. In order to make these assessments, courts are required by Section 60 of the Sentencing Act 2020 to follow all relevant sentencing guidelines. Where the offender is a child under 18, these include the overarching guideline, sentencing children and young people. We call this the principal guideline, and any offence-specific guideline applicable to children. Here, the Sexual Offences Sentencing Children and Young People guideline. These guidelines, read together, require the sentencing judge to follow a stepped approach to assess the seriousness of the relevant offences in context and to determine whether the offence passes the custody threshold. Having done so, even where the court concludes that the custody threshold has been passed, the court is required to review the sentence and to consider the full range of sentencing options. So the fact that the circumstances of the offence are such that it passes the custody threshold does not mean that a custodial sentence is unavoidable. Where the offender is under 18, the court must comply with the statutory provisions set out in Section 37 of the Crime and Disorder Act 1998 and Section 44 of the Children and Young Persons Act 1933, which together require every judge dealing with a child offender, 1, to have regard to the principal aim of the youth justice system, which is to prevent offending or reoffending by a child, and 2, to have regard to the welfare of the child. Sentences for children must therefore be individualistic and rehabilitative where possible. By law, custodial sentences must only be imposed as a measure of last resort and where an offence is so serious that neither a fine alone nor a community sentence can be justified. If a custodial sentence is imposed upon a child, the court must state its reasons for being satisfied that the offence is so serious that no other sanction would be appropriate. The judge's assessment of seriousness was the issue at the heart of this appeal. As we've already said, this was a difficult sentencing exercise, given the number and seriousness of the offences, but also the ages and vulnerabilities of very young children. The judge did carry out a careful sentencing exercise in accordance with statutory principles and the sentencing guidelines that were relevant. He made findings of fact that were relevant to the sentencing exercise, in particular that both C1 and C2 had had consensual activity with at least one of the offenders prior to the offences taking place, that the offences were not pre-planned, and in respect of incident 2, that no knife had been used and C2 had not been forced to give up her phone to avoid being tracked. As the trial judge who had heard the evidence, he was entitled to reach those findings, and he was best placed to do so. In respect of X and Y, the judge was satisfied that their offending passed the custody threshold, but bearing in mind their ages, vulnerabilities, and the time spent in detention prior to trial, he concluded that it was possible to step back from imposing a sentence of detention. In respect of Z, 13 at the date of convictions, and whose role had been limited, the judge concluded that his offending fell short of the custodial threshold. On review, we carried out a detailed analysis of the relevant statutory provisions and the sentencing guidelines. We considered and we took into account a significant amount of information about the circumstances of the offending, the vulnerabilities, and the levels of culpabilities of the offenders, and we took into account the effects that the offending had had upon the complainants, as detailed in their victim personal statements and the harmed person reports. We also received lengthy submissions, in writing in particular, as well as orally, from all the parties. And after we had assessed all this material in the context of the statutory framework, we concluded that the judge had erred in his assessment of the seriousness of the offences. In particular, we found that he had failed to take sufficiently into account the ages and vulnerabilities of the complainants and the psychological effect upon them, which we considered to be severe. The humiliation and the degradation resulting from the filming and the group offending, the number of individual offences, and in respect of X and Y, the fact that there were 2 separate incidents. We found that for each child, the offences passed the custody threshold. But insofar as Z was concerned, although his offending passed the custody threshold, we have found that a custodial sentence was not unavoidable. He was only 13 at the time. He was only involved in the second incident. His role was limited to assisting or encouraging another to carry out rape, and he did not himself take part as a principal. We found that it was reasonable to approach his case on the basis that he had joined a group, X and Y, which had committed the offences in the first incident and was seeking to repeat that behaviour. So we have declined to review the sentence imposed on Z, which we considered to have been a proper sentence and not unduly lenient. But insofar as X and Y were concerned, we reached a different conclusion. Their involvement in the 2 incidents, taken together, was such that an immediate and substantial sentence of detention was required. X and Y participated, either as principals or as assisters or encouragers, in multiple rapes carried out in front of others, and in which the complainants were subjected to humiliation and degradation, in particular by the filming of the offences as they took place. We found that the judge had undervalued the seriousness of their offending and the serious harm caused by it to the complainants. Notwithstanding their young ages and their vulnerabilities, sentences of detention for X and Y were unavoidable. We stated that, had X and Y been adults, custodial sentences substantially in excess of 10 years would have resulted. We reduced the sentences that would have been passed in those circumstances to take account of the mitigation available for each child, time spent before trial, either in detention or subject to stringent bail conditions, their lack of previous convictions, and their vulnerabilities, about which we were provided with substantial expert evidence, and which, particularly in respect of Y, significantly reduced his level of culpability. We then followed the principal guideline, which suggests that where the child is under 15, it may be appropriate to pass a sentence that is less than half that which would be imposed upon an adult. We quashed the sentences imposed on X and Y in the Crown Court and imposed on each of them sentences of 4 years detention under Section 250 of the Sentencing Act 2020 on each count of rape to run concurrently. We also quashed the 10-year restraining orders on X and Y and replaced them with indefinite restraining orders. We have declined to find that either X or Y was a dangerous offender under Section 308 of the Sentencing Act 2020, such that an extended sentence was necessary. The young age of both boys meant that there was a real prospect of development, maturity and rehabilitation. Finally and separately, we have made some comments about the administration of justice more generally. We have expressed our concern about the inaccurate reporting and the misinformed and inappropriate commentary by members of Parliament, the media and elsewhere that have preceded this review and whilst legal proceedings were ongoing. We have been particularly critical of the conduct of the Crown Prosecution Service, which published a formal press release following the sentencing hearing, which it knew, or should have known, was neither a fair or accurate representation of the factual basis for sentence. It was this inaccurate press release that appeared to be the root of the misconceptions that followed, in particular, the misconception that this offending involved a knife-point rape and that C2 had been forced to give up her phone to avoid tracking. These mistakes portrayed the offending as even more serious than it already was. It took almost 3 weeks for the Crown Prosecution Service to correct the relevant inaccuracies.